But first, this morning, we're going to start with a conversation on when regulation of the private sector goes too far, and maybe a little bit on what you can do about that if and when that happens. The discussion is going to be led for us this morning by NBC News Justice Correspondent Pete Williams. Let me thank you in advance for your participation and turn things over to you.
Thank you very much, Dean, and good morning, everyone. As Dean said, this panel asked the question, when does government regulation of the private sector go too far? When does it stray from principled public policy to loading the dice in order to make losers of disfavored companies or practices? Let me briefly introduce the panelists. Over there on his own island is Michael Madigan, who deprived the world of professional baseball of a potential long ball hitter when he decided that his future was in the law, which of course has fewer rules than baseball. He's a, well, this is a hip crowd, you know. He's a litigation partner at Orrick, Herrington, and Sutcliffe, where he's one of Washington's go-to guys in the white-collar defense bar, and along the way he's been a prosecutor, a key staffer on the Hill when Congress was making history, including serving as Howard Baker's counsel on the Senate Watergate Committee. And sitting right here to my symbolically important left is Lanny Davis, who's an expert on Washington, D.C.'s legal and political rituals and ordeals, having first survived, and this is the most important fact about his past, hazing by George W. Bush, among others, to become a member of a fraternity at Yale. True story?
True story.
All right, good enough. As we say in journalism, that's a bonus. He's an experienced litigator and served in a nationally prominent role as special counsel to President Clinton during some, shall we say, stormy days at the White House. And now at Lanny J. Davis & Associates, he helps people and corporations who are looking for crisis management or who need legal, legislative, and media advice, all from one moderately tall native of Jersey City. I'd like to start with something that's actually been perceived as a victory for the private sector, and that's January's U.S. Supreme Court ruling in the Citizens United case, which allows corporations to spend their own money to support candidates or issues. During the midterm campaign, the Democrats, including President Obama, were strongly critical of groups like the Chamber of Commerce that bought political ads, and their complaint was that the individual companies that put up the money were never identified. Here's what President Obama said in one speech, I'm quoting. "They don't have the courage to stand up and disclose their identities. They could be insurance companies or Wall Street banks or even foreign-owned corporations. We will not know because there's no disclosure. They've got these innocuous-sounding names," he said, and specifically mentioned Americans for Prosperity. And then he said, "This isn't just a threat to Democrats, it's a threat to our democracy." So, Lanny, let me ask you first. Is the president right? Is this a threat to our democracy that private groups can put up money for political ads without disclosing the corporate sources?
I think it is a serious threat because I'm in favor of transparency both on the left and the right. But before I continue my answer, I have to do what I do on the Hannity show, which is to actually say what I want to say and not answer his question.
Something that seldom happens in Washington.
And start by saying I want to thank the Federalist Society for allowing me in your midst to address you, especially my friend Michael Madigan, who when I served President Clinton, his more recent vintage after Watergate was to serve as Senator Fred Thompson's counsel when he was investigating the Clinton White House. And I was the defender while Mr. Madigan was, I think, serving as a very effective gatherer of evidence. I won't say prosecutor, but the two of us were doing, let us say, verbal combat out in the hallways after every day's hearings, where the press would gather around Michael and he would do his spinning of the truth, and then they'd come to me and I would tell the truth. And he would actually win the day. I don't know why, but we became great friends in an adversarial situation, and so I thank Michael. And Pete, I used to be told by Mike McCurry, the president's press secretary, when I would try to get Pete to report the way we wanted him to, forget it, he's unspinnable. So that's a high compliment.
Very kind, but certainly not true.
And one other, remarkable person, I hope I don't embarrass him, who's here, is His Honor Judge Bea from the 9th District Circuit in California. I argued a case, I lost, a 3-0 decision. I knew I was going to lose when I began to argue the case because it was a very difficult argument. And Judge Bea, I sort of saw from body language, was at least not hostile. And I hope I don't embarrass you, Your Honor. After the case was over, and without any possibility in my mind that I would ever have to appear in front of him again, he sent me a very kind note about my oral advocacy, and I sent him a copy of my White House memoir. And I just want to say that both in terms of making friends with adversaries in the political arena or being in a courtroom in front of such a distinguished jurist, for him to reach out to me the way he did was one of the most moving things to ever happen to me in over 30 years of law practice. So it's an honor to see you, sir. Now, let's get back to why don't we require disclosure? I left the reservation on Citizens United by supporting the Supreme Court's decision on First Amendment grounds. I've always had a problem with McCain-Feingold because of a belief as a liberal First Amendment person from my days from Tom Emerson at Yale Law School, that the First Amendment actually means what it says and says what it means. And I never understood how liberals were able to distinguish commercial speech or political speech paid for by a corporation or a union from my speech. So I believed on principle that the decision was correct, and therefore many of my friends on the liberal side strongly took issue with me. But on the other hand, I guess why I'm here is to debate a little bit. I do not understand the argument for non-disclosure. I am willing to give up my privacy rights as a liberal when I go through airport security. I was just asked that last night on Hannity, and I said I don't mind being patted down if that's what it takes. I served on President Bush's Privacy and Civil Liberties Board. I was read into the highest classified counterterrorism programs. I served with Ted Olson. And Ted and I discovered that we actually agreed on a lot of things. I don't want to embarrass Ted, but I'm willing to give up rights to privacy if it comes to, if necessary, limit some rights to privacy if it comes to being effective in the war against terror. I do not understand why people who give money to defeat candidates are embarrassed and don't want their names revealed. If they call that's about the right to privacy, then I would say, okay, I respect your desire to be private, then don't give the money. But you give up your right to privacy if you're affecting public policy in an election. Let's be transparent. And by the way, I say that to unions, I say that to liberal organizations, I say that to everyone. I'm consistent. But now that I've said that, I'd like to have the argument, aside from the right to privacy, which I get, against transparency. Mr. Madigan?
Now you see what a difficult job I had up there for a year. No matter what Lanny says and how he says it, it sounds reasonable. But we perhaps need to look a little deeper. Actually, when the Citizens United brouhaha, and Citizens United, many of you know, was founded by our friend Dave Bossie, and ironically got to be the Supreme Court case that went up there. But in any event, the remarks of the president followed up, for example, by the remarks of the head of the DNC, who said that he thought that this non-disclosure was possibly the biggest scandal since Watergate. Now, since I had the honor of serving on the Watergate Committee for Senator Baker, it reminded me of Watergate, because you may remember that one of the things we found during the Watergate investigation was the infamous enemies list. And now we fast forward these 30 years, and these remarks that are made and the comments about foreign money and things of that nature eerily sounds like the administration, and I include the Congress in that term, at least in the last number of years before the election, is preparing and has an enemies list that they are going to attack people like the Chamber of Commerce that we'll get into in a minute, and certainly like Citizens United, there are in the country, both Republican and Democrat, over 90,000 501c6 entities. A famous one called Democracy Alliance, run by Mr. George Soros. And all these different organizations are permitted under the law to have a role in the election process without disclosing the names of all the donors. And we'll get into to some of the issues with respect to that when we talk, I think, about the Supreme Court case and things of that nature. But I find it very troubling that major entities and people are being singled out, or have been singled out by the administration for their beliefs in what is tantamount to an enemies list.
Well, let me ask you about disclosure, because in another Supreme Court case decided this year, it was called Doe v. Reed, the justices voted 8-1 in support of Washington State's decision to make public the names of people who signed petitions to get a measure on the ballot. The group that circulated the petitions had argued that if they were forced to do that, the people who signed them could be subject to harassment. And Justice Scalia voted with the majority, and he said during oral argument, and this was consistent with his opinion, that participating in the political process, quote, takes a certain amount of civic courage. The First Amendment does not protect you from civic discourse or even nasty phone calls. So, Mike, why shouldn't that same principle apply to the corporations who put up money for ads?
And the unions.
And of course the unions. But that's an interesting case, Doe v. Reed, because the court in that case actually remanded it back to the state of Washington. It's an odd, kind of an odd case where you had the statute that Washington passed, which was called Everything But Marriage statute. It was a domestic partner statute, and a group of people got together and got a referendum to put it on the ballot under Washington law, and the opponents of that tried to get the names of the people on the referendum. And what the court held, and as you know, Pete, there were 4 or 5 different opinions, was that the statute itself was not unconstitutional, but that we would send it back to look at whether there would be an exception. They could make the case for an exception to disclosure. Now, in the meantime, the referendum was on the ballot and was defeated. So I'm not sure where, if anywhere, that case is going, but it was interesting at the argument that Justice Breyer raised the question without really answering it. Suppose that, that a number of the civil rights workers back in those very difficult days in Little Rock, Arkansas, had to disclose their names with what they were doing, trying to battle segregation and other controversial issues. So I think, I'm not sure this is the case that's going to decide these things, but the issue of retribution with respect to unpopular causes and these causes in our country that people get so excited and emotional about, understandably. So I think you have to look very carefully at that before you devise a rule that says that everybody who advocates for a particular cause that many people may not like or feel strongly about in certain circumstances have their names disclosed.
Well, the subject, of course, of this panel is whether the government sometimes goes too far. Let me ask you both about an incident that some people, some senators are saying is such an example. And it came from a background briefing, one of these background briefings that the White House gives where they have a senior official who can't be quoted by name. This is a long-standing tradition here. And the Treasury Department's Inspector General is looking into whether confidential taxpayer information was improperly disclosed during one of these briefings. on possible tax changes for corporations. The briefer, the administration briefer, said that Koch Industries is an example of, quote, multi-billion-dollar businesses that are structured as partnerships in ways that allow them to avoid paying sizable corporate taxes. And the senators that wrote the letter to the Treasury and asked them to look into this said that somebody in the administration must have been looking improperly at the company's tax information. And of course, the Koch brothers are the big backers of Americans for Prosperity. So, Lanny, does this seem like an innocent slip-up, or was something more going on here?
Well, I think it's an innocent slip-up. I doubt anybody got...
I think I've heard that before.
Honest mistake, innocent slip-up.
About the Lincoln bedroom or something like that, I think.
It wasn't about money, it was about friendship. Do you mind if I do a segue about that? So, I'm on Nightline for the first time, and that was the line I was given at a time that I was repeating lines rather than saying what I really thought was factual. And on my way home, do you guys mind if I use the vote?
They hate to hear anything negative about the Clinton administration here, Lanny, but go ahead.
This is actually a turning point for me when I really started to do a good job for President Clinton. So I said the line on Ted Koppel's Nightline, first time I was ever on. I don't know if any of you remember, but he actually didn't let you in the same place where he was in the studio. You had to look at a blank wall with a little red eye, and you heard his voice in your earpiece. And I said, well, Mr. Koppel, these overnight guests were all about friendship and support, had nothing to do with money. And he said, wait a minute, Lanny, I'm looking at a piece of paper with President Clinton's handwriting. It says 100K, 50K, let's move promptly. I don't see any word friendship there. And I tried to go back to my message about, well, they were really friends. On my way home, my oldest son, who you may know from NCAA television coverage on CBS, is the very good-looking young man, great on television, totally unlike his father. Between Greg Gumbel and Greg Anthony on the halftime show, his name is Seth Davis, and I'm very proud of him and I love him. But he is a journalist, so he's allowed to talk to his father this way. On my way home, my cell phone goes off, and it's Seth. And I said, hey, Seth, you see me on Nightline tonight? He said, yes, Dad, I did. I invited over all my friends to watch it. I said, well, how did I do? He said, well, you really want me to tell you? I said, yeah, I'm interested. It's my first time on Nightline, and I'm just early into my job at the White House. Tell me. He said, well, Dad, even I knew that you knew that you were full of shit. Only a son gets away with that. No. So, what was the question?
Taxes.
The issue of privacy and what might have happened at the White House in violating Koch Industries' rights to privacy in its tax returns is a very important issue to liberals. And so when I say transparency, I know that there's a tension between forcing people to reveal themselves, and Justice Breyer's comment troubles me, and Michael, who is a great friend and a great lawyer, what he says troubles me about retaliation and retribution in the sense of enemies list that happens in adversarial partisan politics on both sides troubles me. So the tension between those privacy rights and the public policy issues of what transparency is about in a society that depends on transparency as the fundamental bedrock of our democracy is a tension. And I faced that tension on the Privacy Board when I had to decide about the terrorist surveillance program. And Ted Olson and I went back and forth on some of the issues involving privacy issues and the president's program. And as I said earlier, body searches at airports. There is a tension. But for me, I opt for transparency and go after people who are retaliating, who are doing enemies lists, who are doing anything as a consequence of speech. And it really does, my final comment, go back to my class with Tom Emerson, who defined First Amendment expression as a way of limiting it to expression, and when it then crosses over into being the equivalent of conduct, that's when you regulate or stop it. And that's the fire in the movie theater analogy, exception to First Amendment rights, when your speech has such immediate adverse consequence that it's no longer speech, it becomes conduct. That was the Tom Emerson paradigm. So Michael, anything that's retaliation against the chamber or against a union or against anyone, we ought to prosecute them and put them in jail or do whatever it takes to stop the consequences of speech. But I'm still opting on a balance, on a tough balance, in favor of transparency.
And of course, I agree with always with part of what Lanny says. And going back to Watergate, you remember that one of the more egregious things that the Haldeman Ehrlichman crowd was doing was pulling tax returns of various people on the that they perceived to be on the left side, and it was roundly condemned by Senator Baker and everyone else. So when we hear the confidential tax information, a company like Koch Industries and the Koch brothers, you know, have built this into one of the, I think it's the largest private energy company in the United States. Done a terrific job. The great philanthropists have spent millions of dollars in cancer research and others, and are openly, there's no non-disclosure, no lack of transparency. David Koch is listed openly as the chairman of the board of Americans for Prosperity. But when these kind of attacks are made by unnamed administration officials, it really has a chilling effect, because the power that you have in government is a precious thing that needs not to be abused, and there is a great danger. We've seen it in our history, a great danger of abusing power. I remember in my young federal prosecutor days, we used to get these cases which were the bane of our existence, where people called special police officers in different stores and places would make all these arrests and do all these things because for the first time in their life they had a badge on and they had some power, and they abused it. So in our democracy here, we have to be very careful not to abuse power, and those are the kinds of things, when you hear this kind of thing, that I think is very troubling.
Let's turn to another Obama administration effort. This was the creation of a position called the Special Master for TARP Executive Compensation, better known as the PAYSAR. Let me ask you both, do you think this was an example of excessive government intrusion, leaning on private companies to keep a lid on the size of the bonuses that were paid? Lanny?
Well, I do have a question about its legal basis. So I am a lawyer, and I believe in the Constitution. I know some people in Federalist Society don't think liberals do, but we do. And I was troubled and am troubled by any non-legally founded person in government, whether it's a conservative administration or a liberal one, where decisions are made that don't have a specific statutory basis. So I don't know what the basis of that compensations are. As powers were just political pressuring, or was there really any kind of statutory enforcement mechanism? If it was just purely, which I think it was, more jawboning, presidents have done that since John Kennedy jawboned the steel industry. In this case, we were at a time where high political sensitivity with executive compensation being awarded to people who literally were responsible for some of the major companies in our country collapsing, and yet they were being paid hundreds of millions of dollars in bonuses. That was a political issue which an appropriate politician is allowed to criticize, and calling that person appointed by the politician a czar without any statutory powers behind him doesn't really trouble me. That's part of the to and fro of the political marketplace. But if there was any attempt to enforce those statements, I'd like to see, and I'm concerned, that there was an absence of legal foundation for any kind of authority by an appointed czar of whatever. There's so many czars, but this one was compensation. And I'm sort of troubled by the word czar to begin with. And it's unfortunate that we have so many of them. We ought to get rid of all of them as far as I'm concerned.
Mike, the premise of my question was a concern to a lot of people, but why isn't the answer, well, if you didn't want this interference, just don't take the government's money?
Well, I think there are a number of ways that it could have been done, and you saw from Lanny Davis's answer what an instinctively terrific lawyer he is. He kind of tries to pretend he's not a lawyer, but he has brilliant legal instincts. And I think it's the way, Pete, the way that it was done. As a shanty Irish oldest of 8 kids, the notion of a czar is something that
That's right.
Makes my blood boil.
Nice Jewish boys think the same thing about the czar.
And so there are other ways to do it. There was no statutory authority. I mean, I love Kenny Feinberg personally, and is a very talented individual. But and we later are going to talk about a car czar. I assume that this is sort of outside the law, and I think is not bad precedent to try to have our government proceed in that way.
Well, all right. Speaking of the car czar, columnist Michael Barone used the term gangster government after a lawyer involved in the Chrysler bankruptcy negotiations claimed that the administration pressured bondholders to back off their position on how much they wanted on the dollar for their secured debt, which I think the car czar said should be 33 cents on the dollar for their secured debt, as opposed to the more favorable term, something like 55 cents on the dollar for the United Auto Workers for their unsecured debt. And the White House insists that there were no threats, but the bondholders, lawyers at least, say that there were, that they were leaned on, and that their contract rights were violated. And let me just ask you, was the administration, was the car czar, Mike, out of line here, or was this a reasonable attempt to try to get everybody to come to agreement?
Well, I think I've heard it called the UAW Relief Act. So I think the car czar was way outside the line. There obviously are differences of opinion with regard to whether the car company should have been bailed out in the first place. And there are, even going forward, there are billions of dollars of unfunded pension issues out there. And once again, I think the mechanism was outside the law, and that there should have been a different way of doing it. When you go through the bankruptcy, and we had this whole debate in that was going on during our financial crisis as to whether certain companies should be allowed to go through, or forced in effect to go through the bankruptcy process rather than the government relief program, and you can debate that on either side. But to do this kind of thing, again, I think doesn't follow the rule of law. And whether we're Democrat or Republican, when we don't follow the rule of law, we get in trouble.
Lanny, the object, of course, was to save jobs, and Chrysler's third quarter reports, anyway, shows an increase in operating profit. They're, of course, owned by Fiat now, but does this suggest that the administration did the right thing here, to hold everybody's feet to the fire and get a deal?
Well, since everyone in this room is intellectually consistent and honest and is willing to give credit where credit is due, we ought to give credit to President Obama for what happened with General Motors, because the taxpayer is going to make money on that deal. And every Republican that criticized the GM bailout as being socialism needs to take it back and apologize to President Obama. I'm sure everyone in this room will join me in that apology.
You may have lost them, Lanny.
Look, I'm very troubled by this notion, and I was a little too facile in saying jawboning is okay, but coercion without a statutory foundation is not. it's quickly capable of blurring those lines if you are in a position of authority to hurt someone in your jawbone. So there is a danger here. I agree with Michael. I promised the organizers of this conference, who were kind enough to allow me to be even in the room, much less up here, that I wouldn't agree with Michael too much. But on this one, I do agree. There was a point where the political argument that I think President Obama, facing the crisis, was entitled to make about excessive compensation to people who were culpable and shouldn't have been awarded. That's a political argument he's entitled to make as president, and his co-politicians in the Democratic Party are entitled to make that argument. And have it out in the political marketplace is one thing, but to engage in what looks to me as almost an extortionate threat with somebody that can hurt you troubles me greatly without a legal foundation.
Well, you just praised the Obama administration, Lanny. Let me ask you about something you recently wrote that's critical of them, and that's a regulatory move that has attracted some attention. It's proposed by the Department of Education, and it applies to for-profit colleges. The administration argues that many of these schools do not adequately prepare their students for the jobs that they're all but promised, and that it just suckers them in and then saddles them with a lot of student debt. The schools would have to comply with new rules for tracking job placement rates if they want to continue to qualify for federal aid. You wrote recently on the Huffington Post, Lanny,
a conservative site, by the way,
that this effort is partly the result of an instinctive reaction of many liberals to the word profit when applied to education. What did you mean by that?
Well, first, full disclosure, I'm paid by a coalition of for-profit career colleges, and I took the account because I saw the consequence of this regulation as hurting the kind of students that attend career colleges, who are usually predominantly low-income and minorities. And I saw the paradox of a liberal administration. Some people like to use the word progressive. I'm a liberal. Putting a regulation out that targets just the for-profit schools and ignores the same abuses that are going on at public universities that are vacuum cleaners for tax dollars, as well as some of the nonprofits that are vacuum cleaners for federal contracts in the billions of dollars. They're ignored. The only sector targeted are for-profits. And I tried to figure out the paradox of a progressive, liberal, democratic administration putting out a regulation that hurts low-income people and minorities, otherwise known as our base. What's wrong with this picture, I asked. And I started out my column by saying genuinely, if my old buddy, fraternity brother, and I will never discuss the ritual we went through, by the way.
Please don't.
If George Bush had proposed a regulation that deprived lower income and minority students of federal loans and left everybody else alone, can you imagine what liberal Democrats would be saying about President Bush? So as an advocate now, I'm hired by this coalition of for-profits. But I wouldn't write and I wouldn't advocate something I didn't believe. If I'm in court defending my client, I do what I have to do as a lawyer, and I do the best defense possible. If I'm publicly advocating something, I've got to believe what I say. That's my rule. So just a quick segue, I'm at a hearing on this by Senator Harkin, someone who, as a liberal Democrat, I supported when he ran for president. And I criticized in this column for this regulation that I think shows that excessive regulation hurts people like me who believe in regulation. And in comes John McCain with a kind of mischievous look on his face. And I have to admit, I did send the Huffington Post column over to him. And Senator Harkin sees John McCain come in the room and says, Senator McCain, you have 5 minutes? And Senator McCain says, I would like everybody to mark the date and the time of what I'm about to say. I want to say there's somebody in this room named Lanny Davis who, for the first time ever, I agree with. And then he started to read the Huffington Post criticism, and of course, he enjoyed it greatly. Al Franken was sitting on the Democratic side, and I've known Franken for a number of years, and when he gets angry, let's say he's not exactly a nice person. And I've been the brunt of his anger when I supported Joe Lieberman in Connecticut, who's godfather of that son, Seth Davis, who talked to me the way I told you. And I've seen Franken at his worst, and he can be pretty bad. So after McCain quoted my column, Franken said, "Lanny Davis wrote that column because he's a paid lobbyist." He didn't believe a word of it. He's a paid lobbyist. And I just wanted to stand up and punch him in the face, but I didn't. I'm a nonviolent man. But anyway, this is an example of good objectives, regulators trying to fix some of these abuses that are terrible. Their kids are exploited and take on too much debt, and diploma mills that take federal dollars. Those people should be thrown in jail. But the column I wrote was titled "The Liberal Paradox." And the paradox is, why would liberal regulators target just the kids that are most vulnerable in our society? And it's not just kids, they're working mothers, working people who go to these career colleges part-time. Why would they do that? And I think it's about the word profit. I think there's an assumption that government can do it better, and that actually the profit motive is bad, when in fact these career colleges go out of business because they're in the marketplace and they've got to attract customers. If they don't do a good job in the free market, they lose. If you don't do a good job and you're the government, you keep going. And I say that as a liberal Democrat. So to my friends who are in the Obama administration, and I support President Obama, and to my friends who are in the Department of Education who are drinking ideological Kool-Aid and letting it trump facts, this is an example of bad regulation that makes people like me who favor reasonable regulation embarrassed.
We have about 15 or 20 minutes here, and we want to hear your questions as well. And as you prepare for that, let me just ask one additional question of Mike on a different subject. In mid-September, the Secretary of Health and Human Services, Kathleen Sebelius, sent a letter to the health industry's trade group warning them not to spread falsehoods about some of the effects of the new health care law. She wrote that some insurance companies were blaming the new law for a raise in premiums, and she said in her letter the following: "There will be zero tolerance for this type of misinformation and unjustified rate increases." Mike, was this a heavy hand here, or was she simply warning the companies not to do what many Americans suspect that they are doing, which is using the new law as an excuse to raise rates?
I think it was pretty obviously a heavy hand. It's part of the tsunami of new regulations that the healthcare bill produced, which was, you know, rather amazing to sit back and watch. The administration basically turn the keys of government over to Senator Reid and Mrs. Pelosi. But to then turn around and when people don't like the various parts of the health care bill or the whole health care bill, I didn't think, by the way, Lanny, we could get anything worse than Hillary care, but we did. So to try to stifle that by threatening in effect, and this wasn't a very subtle threat, to utilize some of the regulations against anybody that would speak out about various parts of the bill is once again this use of government power that is frightening and is not in keeping with our system.
How about that, Lanny? The Wall Street Journal said after reporting on this that, quote, "zero tolerance for expressing an opinion or offering an explanation. They're more subtle than this in Caracas."
I refuse to agree with a single Wall Street Journal editorial. But I will address the principle. I believe Secretary Sebelius misspoke and doesn't mean what she says. I'm sure that she would want to take back any suggestion that an opinion and an expression of free speech, which is fundamental to every liberal that I know. And it was the McCarthy era that taught me that there were people on the right that didn't believe in free speech. I actually think the right and the left do agree on this principle. But I think that was an improper statement by Secretary Sebelius. She's a very fine person, and she should say I misspoke. If there is fraud under the law of increasing premiums that I don't even know what statutory basis there is for regulating a free market decision to increase prices, but it may have something to do with Medicare or reimbursement regulations. But I just think any suggestion, again, sorry folks to agree with Michael again, that free speech should be intimidated or in any way threatened, I think is wrong.
Let me ask you both a question about the overall theme of this conference, which is, this panel anyway, which is the government singling out businesses to pick winners and losers? And I'll just ask you both this question. Do you think that this administration has a sharper ideological edge, improperly so, when it comes to business?
It certainly appears that way. Hopefully the election that we just saw might have an effect of changing the approach. But once again, I come back to this notion of power in the hands of people who have not had power previously, and the very dangerous use of that power. And it appeared to be that that's the way that we were headed. I would hope that as we go forward, that will not be the case. But it's a danger, whether it's a Republican or a Democrat administration, to have this power. It has a huge government power with the regulatory, almost everything in private business is regulated in one fashion or another, and whoever is in control at that time controls the power of those regulations.
Lanny, briefly.
Look, this is one of those places where both sides are hypocritical, and I hope you all will take a consistent position. We saw the misuse of governmental power under my friend George Bush's administration. We saw misuse of power in the Justice Department, asking people whether they believed in right to life as questions to be posed about getting a Justice Department job. We've seen misuse of power under both executive branches, under Republicans and Democrats. I do feel the Democratic Party needs to go back to the party of Paul Tsongas and Bill Clinton, which said you can be pro-business, pro-free market, and a liberal Democrat. They're not inconsistent. There's tension between regulating business and the free market. And we've found over 2 centuries a way of trying to balance that tension in a way that is reasonably acceptable to free marketers and people who are looking for social justice as an outcome. But that tension is a healthy tension. It's what elections are about. But I am concerned that right now the perception of President Obama as anti-business, which I think is incorrect based on his campaign and his record. He was supported by business in his campaign. His record as a United States Senator was pretty moderate when it came to business issues. To depict him as anti-business is unfortunate. I do believe that he and his administration came across that way and were allowed at least to lose the message wars by being depicted that way. And I think we Democrats have to do a lot better job of repositioning our party back where we belong, which is where Bill Clinton placed us. We were fiscal conservatives, we were cultural moderates, and we were social liberals. And we combined those 3 things to change the electoral map and to compete for the presidency and even win support from the business community by the end of the 90s. And I think Barack Obama kept that electoral map going in 2008 by running on those kinds of moderate themes. And I think if I were advising him, and he doesn't take my advice, I don't think, I would say learn from 2010, pivot the way Bill Clinton did after '94, and get back into the center and reach out to the business community.
A couple of questions from the floor. Yes, sir.
Good morning. I was wondering what you gentlemen think on the health care bill and talking about overuse of government power, of the well over 100 exceptions that have now been granted to various organizations, many of whom have ties or have supported the Obama administration, to some of the more onerous restrictions that are called for in the bill. what do you think of the propriety of all that?
I'm not sure I know which ones. You want to give me one example, because I'm unaware of any of those.
It's been reported that many of the labor unions, for example, have been told that they're exempted from various provisions of the healthcare regulation. That I suppose there's some procedure where you apply for an exemption, and you know, there's some executive review of this. But you know, many that's been reported that have come out are labor unions and other, you know, very large business organizations.
Well, I'm against discriminating based on political judgments. If there's a reason on the merits why a particular exemption, and it applies to a union, it ought to apply to a business or anybody else in the same situation. If it's a political judgment based upon favoring somebody on their politics, then I would be against that. I'm a pro-labor, pro-union Democrat. But if that's happening, I would say it's wrong.
Well, there are a host of problems, as you know, with the health care bill. The first is that most of the people that voted for it have no idea what's in it. And secondly, the tsunami, as I put it, of regulations that are in the process that you refer to are just an absolute nightmare. And they certainly should not. I'm not familiar with exactly the exceptions you're talking about, because I'm not a healthcare expert. But needless to say, I agree with Lanny that they need to be objective and not singling out your friends and opposing your enemies.
Thank you, sir. In the back, yes, ma'am.
Thank you. I want to go back to you, Citizens United, because I think you actually could have analyzed it a different way, and maybe you'll agree with me and have things to say about it. McCain-Feingold had a universe where there was a cap on how hard any politician could shake down a business or a corporation. And my concern is that the unintended consequence, or maybe the intended consequence, but the unstated result of Citizens United is there's no cap, that the shakedown will just never cease. If this is a panel about what government can do to businesses, I think that analysis might take up a minute of the panel. Thank you.
Of course, there's the difference is that McCain-Feingold applied, the cap applies to contributions to candidates, whereas Citizens United is unlimited amounts of advertising. But what about that, Mike?
Well, I'm not sure I agree with that. I don't think that we'll know the full ramification of this until we go forward in terms of where this is going. I would expect you're going to see some effort at legislation. That's what seems to happen in this arena, that as soon as something is decided by the courts, the legislation is passed. So I really don't know where we're going. We certainly saw in this last election large amounts of money being used by both sides.
Look, I have a very hard time with any concept of regulating speech. The argument in favor, on the constitutional argument in favor of regulating the amount of money people can give, is because of the avoidance, going back to Watergate, Michael, of corruption and influence by money in politics. I've heard conservatives argue against McCain-Feingold during the days when there were debates about McCain-Feingold, that the answer isn't regulating speech. The answer is immediate transparency. Now, that is the argument conservatives made. Now I'm told transparency is a bad thing if you go through a third party. If you do it directly, you have to be transparent. If you go through a third party, you can hide. I'm sorry, you can't be intellectually consistent to say both of those things. So I solved my problem, and this is a problem. This is a tough issue. Anyone who sees this easily isn't seeing all the nuances of it. And I'm not an absolutist, Justice Black, First Amendment. There are times that you have to, as in shouting fire in a movie theater, there are times that you have to regulate speech. But I would say the ultimate answer still is transparency, and I still haven't heard an adequate argument, aside from the privacy issues that we are willing to compromise under other circumstances. Why not here? I don't see why we don't solve this problem, even if people are spending too much money. The corporations giving the money to all these organizations should stand up and say, yes, this is what we believe in, and this is why we're giving the money, and we'll stand a consumer boycott if you don't like it. That's the consequence of giving that sum of money.
Yes, sir, in the front.
And I just wanted to, I know Eugene was up before me. In case we run out of time, I wanted to defer to the back for one.
Very good.
Okay. And it's really following on the gentleman before me that as someone who kind of declares themselves a pro-union, pro-labor supporter, would you concede that especially in the free speech context, that the tension between unions' expression where there's an element of compelled membership might bear a different weight than sometimes there's an attempt to analogize efforts there to sort that tension out with the efforts in the corporate arena, where I tend to think people aren't compelled to buy the stock of a certain corporation and can't abandon it if there is transparency. I agree with you on that.
Well, there are two issues that I'm not sure which one you're addressing, maybe both. One is compulsory membership, or you have to pay your non-membership fee if you're in a union shop, and that's the right to work versus not right to work states. And the other one that I thought you might be referring to is the card check issue, where people are forced to declare whether they want to be in a union or not in a public way, so that a union organizer knows whether you say yes or no.
If I could, I was actually
Which
going
one?
to the point of whether the unions can use dues for political speech.
So there's the third one.
Yeah.
So let me just quickly say on the first one, I believe in the right to organize, and if you get the benefits from a union, you should pay for those benefits. If there's a collective bargaining agreement, I'm obviously not in favor of the right to work laws, but if I said I were, then I'd have no liberal principles left. On a card check, I did work for Whole Foods, Costco, and Starbucks on an anti-card check bill group, and we called ourselves Committee for a Level Playing Field. I found the card check offensive because it didn't obligate a secret ballot, which is a liberal principle, but we also thought there should be equal access to the workplace so workers could hear the argument on the merits pro-union and anti-union. So we kind of split somewhere in the middle on that. And on the issue of compelled going along with a union contribution to a political candidate, I do see distinctions, although my law school professor might have said a distinction without a difference. The fact is, shareholders don't get a right to decide when a corporation makes a big check, 90% of which go to Republicans, even though the shareholders may be 90% Democratic. Of course, they can vote their board out. We all know how meaningful that is. I think that both unions and corporations have a serious problem on the principle of conferring with their grassroots before they make a decision how to spend their grassroots money. And I do see a parallel between shareholders and union members, but it's not a clear parallel, but there's certainly an analogy.
Mike?
I just think this is a debate that will take another hour or so to do. It's been around for quite a while, and we have not found a solution to it.
Thank you. Yes, sir, we'll make yours the last question.
I was just some of the exemptions were for major classically McDonald's and Jack in the Box and a bunch of others. And it led to the question I have, which is if you have a lot of a huge number of regulations that exist, and you sometimes argue for enforcing one and sometimes enforcing the other. Don't you have a big problem with the government essentially, almost of necessity, picking favorites, and there's so much is technically perhaps against the law or perhaps required, that you're making a judgment not just on enforcing the law but on which laws shall we enforce? And does that
what about that, Mike?
bother you?
Yeah, so the answer is there should be less regulations. A decrease of about 85%.
And the answer is that when Republicans are in power, they love to regulate unions in the left, and when Democrats are in power, they love to regulate corporations in the right, and both sides seem to like earmarks when the earmarks are going to them, but not to the other guy. But in general, I think government is about picking favorites, and politics is about picking favorites, and elections are about picking favorites. It's an unfortunate part of our sausage factory, and it's democracy. It's not very pretty, but it's better than the alternative.
Thank you for your questions. Thank you, Lenny Davis and Michael Madigan.